Sveiki visi. Esu Andrius Ankauskas, komercijos atašė Kinijoje. Daugelis iš jūsų jau mane pažįstate, esame bendravę. Su kitais, su kuriais susipažinsime šiandien, malonu susipažinti. Šiandieną mes visi susirinkome, manau, labai aktualią temą, pasiklausyti apie esamą situaciją Kinijoje intelektualinės apsaugos srityje. Kai kuriem ši informacija yra jau žinoma, kai kurie galės atsišviežinti žinias, o manau, nemažai daliai bus tai ir naudinga pasiklausyti kaip pirminį šaltinį, kas dabar vyksta Kinijoje ir kokių veiksmų reiktų imtis tam, kad apsaugoti savo produktus. Šiandieną turėsime ekspertą, Matias Zubimendi. Jisai yra būtent teisininkas, kuris darbuojasi šioje srityje. Taigi labai paprašyčiau visų būti aktyviais ir užduoti kiek įmanoma daugiau klausimų, kurie jums neramina, nes šiandien yra tikrai puikia proga tiesiogiai sužinoti informaciją, kurią yra sunkiau surasti internete arba iš kitų šaltinių. Taigi, tai tiesiog yra galimybė, kada jūs galite užduoti klausimą ir sužinoti informaciją, kuri jums bus naudinga ateityje arba šiuo metu. Tai pati prezentacija truks apie 40 minučių, po to mes pereisim į klausimų ir atsakymų sesiją, tai per prezentaciją jūs galite laisvai pamatyti apie savo klausimus, kuriuos norėtumėte užduoti, arba jeigu jau turite dabar juos sugalvoję, jūs laisvai galite urašyti į bendrą chatą. Taip, tai va būtent klausimus rašykite čia, arba jeigu jūs norite juos užduoti gyvai, bus tokia galimybė, tai kada pasibaigs prezentacija. Tai tiesiog pakelkite ranką ir jums bus įjungtas mikrofonas ir tada galėsite užduoti klausimą gyvai. O visos prezentacijos metu laisvai galite rašyti į chatą, aš po to garsiai perskaitysiu tą klausimą ir ekspertas pabandys į jį atsakyti, jeigu turės tuo metu tą informaciją. Jeigu ne, mes su juo jau kalbėjomės, kiekviena įmonė galės turėti individualią nemokamą sesiją po to, pasikalbėti jums rūpimais klausimais. Tai dabar aš jau persijungsiu į anglų kalbą. Šitas seminaras vyksta partneriaujant su China IPRs Helpdesku. Tai yra nevyriausybinė organizacija, kuri būtent įsteigta Europos komisijos ir visiškai nemokamai konsultuoja būtent intelektualinės nuosavybės klausimais, tai visada galite kreiptis į juos būtent tos pradinės informacijos gavimui. Ir jie tikrai jūs galės nukreipti, jeigu jau yra kažkokios tai taip, pabandykim, ar dabar geriau girdisi. Čia gali būti, kad iš Kinijos garsas truputį prastesnis, tai čia su tuo reikės susitaikyti, nes karts nuo karto gali trikdžių įvairiausių pasitaikyti. Tai gerai, aš dabar persijungsiu jau į anglų kalbą ir tikiuosi jums šis seminaras bus naudingas. Kaip ir minėjau, raginu aktyviai užduoti klausimus ir po prezentacijos galėsime padiskutuoti jums rūpimais klausimais. Okay, Jennifer, so I made a short introduction, so I'm giving a word to you to tell about the webinar and your organization. You need to turn on your microphone.
Good afternoon, or I would say good morning. This is Jennifer from China IP SME Helpdesk. China IP SME Helpdesk is a European Union funded project which is designed to help European SME with intellectual property right issue in mainland China, Hong Kong, Macau, and Taiwan. The project offers a variety of services that enable EU SME to make informed decisions about the IP right. And all these services are free of charge. You could get our support via inquiry helpline, training, seminars, or some business tools and solutions on the website. The inquiry helpline is for EU SME to ask us any IP-related question. And normally you will receive reply with 3 working days. So just send us the question to this mailbox. The help desk also collaborate with Chamber of Commerce, business associations, cluster organizations, and embassies, jointly organize some training seminars and live webinars all over China and in Europe. The event may cover some very basic IP topics or some tailor-made seminars on a specific issue. So, and if you're interested, please just check the agenda and the schedule on the website. If you go to the website, actually, besides the calendar, you will find many different resources on IP issue, such as e-learning modules, podcast, infographic, case studies, and etc. It also contains a comprehensive library of IP guidelines, which covering all major IP topics, consist of trademark, copyright, trade secret, patent, and GI, etc. Here, some example, as we also offer some industry-specific guides, such as IP in Industry 4.0, or IP protection for AI technology or blockchain China, as well as some details like how to record your trademark with the customs authorities, or how can I remove the counterfeit product from e-platform. That's all about us. You are always welcome to send your inquiry to the inquiry helpline at any time. Today, the speaker, Mr. Matias Zubimendi, is the IP business advisor at China IP SME Helpdesk. He holds a master's degree in Chinese civil and commercial law, plus master's degree in intellectual property law. Matias has really strong background in both business development and IPR protection, as well as extensive experience in terms of the legal affair, patent, and trademark issue. So next, let's welcome Matias to share his experience and knowledge about today's topic. Matias, the floor is yours.
Thank you, Jennifer. Hi to everyone, and welcome to the presentation. We're going to discuss, let me see if I can, here. It is a table of content of what we're going to talk and discuss today. My goal here is to first do a brief introduction about what intellectual property rights are, explain which ones are relevant for the laser industry, talk a little bit about each one of them to highlight how to protect them, what are the most common problems or the most common scenarios that EU companies may face when they are coming to China. And then finally, to discuss a little bit about technology transfer and due diligence. Finally, I will finish with some takeaway messages, and we will proceed with the Q&A section, where I invite you to ask all the questions that you may want. So if during the presentations you want to take notes and later bring up any topic or any aspect that you want me to develop further, please, you're more than welcome to do so. But let's talk about intellectual property rights in general. When we talk about intellectual property rights, what are we talking about? What can I do with them? Basically, they are a monopoly over a certain aspect of life. In the case of patents, for example, over a technology. In the case of trademarks, over a sign that allows companies to distinguish their product or the services within a market. What they give is a monopoly of performing certain specific acts, for example, to manufacture, to export, to import, to sell, to license. This means that the company that owns the intellectual property rights will be the only one capable of doing such acts. That's why it's so important to be the owner of the intellectual property rights in China. Otherwise, your company may be stopped from, for example, exporting and importing. Also, the IP owner will be the one that will be able to provide licenses to other companies, to third companies, in order to obtain some profit from that, or to, for example, cooperate or even do some research and development. But also we have to learn about two main principles that are very, very important, and the consequences of them are or can be critical. The first one is the registration principle. It says, this principle says that only that the IP that is registered is the only one that will be protected. In the EU, this is not so strict. There are some intellectual property rights that, even though they are not registered, they have certain level of protection. For example, well-known trademarks are protected even if they are not registered. Designs patents are protected in the EU even if they are not registered. The protection is only for 3 years, but they are still registered. In the case of China, this is not the case. If you don't have your trademark registered, if you don't have your patent, if you don't have your utility model, you won't have any protection. And this also should be combined with the sub-principle called the first to file, or the first to file rule. That means that the company that is the first one in filing the application for that intellectual property right will be the one that will have the priority over that IP. It doesn't matter if the registration is done in bad faith or not. They will have the priority, which means that if someone starts a registration, even in bad faith, before our company, we will have to first take down that first application, and then we will be able to get our own. Also, there is a second principle that is very important, and it's called territoriality. This principle says that an IP right register will only grant protection within the territory of the country where it was registered. This means that all the IP rights that we have in the EU will not grant any protection in China. The same way, what we have registered in China will not grant protection within the EU. We also have to understand that in the case of China, when we talk about territory, we have to separate 4 different jurisdictions. We have mainland China, Hong Kong, Macau, and Taiwan. Separate these 4 jurisdictions is important because each one of them has its own intellectual property right office. So if we want a full protection within the entire territory of China, we need to do 4 different applications with the 4 different offices, which of course involves more cost. If we only register it with the CNIPA, which is the China National Intellectual Property Administration, we will only have protection within mainland China. If we want to be protected in Hong Kong, we will have to go to the National Office of Hong Kong. Said that, we can learn now how these 2 principles combine and how important it is to register in China what we have registered before in the EU. And I'm going to stress a very important rule. You don't come to China without registering in advance your intellectual property rights. Full stop. If you do so, you are risking yourself to losing your IP, or that it will be copied or registered by a bad faith party. But what intellectual property rights are relevant for the laser industry? What IP should we pay attention to? The first one and most important is invention patents and utility models. What they protect is the technology. They protect either products or industrial processes. Invention patents and utility models, even though they are not the same intellectual property right, they share the same requirements. So that's why they are very connected. Sometimes utility models are so-called small patents because they have so many aspects in common that companies normally do a parallel registration of both of them. And later I will explain why. By trade secret, what it is protected is any information that is secret, that has value for being a secret, and that is kept secret with some specific measures that the company have to take into consideration. Trade secrets have the particularity that this is the only intellectual property right that cannot be registered by definition. Trade secrets remain protected as long as they are kept as secrets. And even when we try to enforce them, we are not going to quote any intellectual property right law. We're going to quote the unfair competition law. And if we lose the protection, we are not going to be able to obtain it back. Simply, we will be compensated for the damages, but no future protection will be possible. Which is important to highlight is that, as we will see with every single of the intellectual property rights, as long as they are not registered, and so as long as they don't have protection, and because they can be registered in bad faith, those technologies, those brands, those pieces of work should be kept as trade secrets. They should be protected and they shouldn't be disclosed to the public unless to a competitor or a distributor or a client. And we will discuss this, or we will see this in more details. With design patents, what we are protecting here are how our products look like. Is the aesthetic aspect of the product. It's only how they look, how they're presented to the public, and no usage of functionality over the product will be protected by design patent. If there is a function, if there is a technology, then we're talking about invention patents, not design patents. By copyright, what companies can protect is the expression of ideas. For the laser industry, when I was preparing this presentation, I was trying to think what can be protected by copyright. And you should take into consideration that in China, copyright is the main way of protecting software, the same way is the main way of protecting database. So if you are commercializing an important product or a complex product that also involves the usage of software or the usage of database, then this can be protected with copyright. We shouldn't think of copyright only for protecting pictures, videos, or books. They do protect that, but at the same time, they protect certain products, let's call them products, that are relevant for industries. Finally, last but not least, trademarks. By trademarks, what we are protecting is every aspect and design that helps a company to distinguish their products from the competitors. It could be logo, company name, product name, anything, colors, sounds, etc. In the case of China, because the market it is complex, there are many jurisdictions. What is advisable is to think the IP protection as an overall protection. Not believing that because we have a trademark, it's enough. We should start combining different registration methods. For example, if we have a logo, we can register it as a trademark. But also, if the logo has draw, we can register it as a copyright. If we have a very specific design, we can use a design patent. But if this design is useful for catching attention from potential clients, then maybe we can also register it as a trademark. So as long as we have, or the more IP rights we have, the better to enforce it. This is particularly true in the case of copyright and trademark, because some of the jurisdictions, they only accept infringement for copyright, for example. So this will, if we don't have copyright infringement, if we don't have the copyright protected, we won't be able to claim it, we won't be able to apply to that jurisdiction, and we will lose a method of protection. Yeah. But let's begin with the invention patents and the utility model protection. As I mentioned, what they do protect is a technology over a product or over a process. How to start the registration or how to protect it in China? There are two different ways. The first one is going directly with the CNIPA. You go directly to the Intellectual Property Administration and you present or submit the application. If your company is already based in China, this means that you are registered and you have an address here in China, then your company can do it by itself. You won't need the assistance of any professional. Said that, due to the complexity of invention patents, it is highly advisable to have an expert cooperating and writing the claims for our patents. It is very, very important, and I cannot stress it more, that as much legal assistance you have from experts, the better. If you are not based in China, then your company won't have any other option than hiring a local patent attorney to do the registration for you. It's one of the requirements and it cannot be avoided. But there's a second option, which is the PCT. The PCT is an international agreement that allows individuals and companies to start the registration in their own country and expand it to search jurisdictions. So you will be able to start the registration in the EU and then expand it to China. This process, of course, takes longer, just a few months, but it gives the advantage that you can start it in your own country with your own patent attorney, or even by yourself, and it's easier because you don't have the language barrier. If you're applying for several jurisdictions, because you may be protecting technology not only in China but in other countries as well, it could be cheaper, because that way you would be avoiding paying an expert or a law firm in each single country. But what can I register as a patent? Well, you can register products. This means final products by themselves, or you can register parts of products, or you can register processes, industrial processes. For example, a manufacture process with different steps, how to manufacture certain products. You could register that as a process patent. Also, in the case of China, software under certain specific conditions can be protected with the patent. I will say that is an exception more than a rule. In order to protect software as patent, the software should be part of a more complex process that involves software and hardware, in which the software is the one in charge of solving the technical problem that the patent is trying to solve. So, as you can imagine, these type of patents are very complex. They need to be drafted by very good experts. And as I mentioned, it's more an exception than a rule. But also, as I explained briefly before, there is another IP, the utility models, which are so-called small patents, and they share the same requirements as invention patents. So why do we have two different IP rights for protecting the same aspect of a product or of a process? Because there are two different ways of doing this registration, or the registration process is different from both. While With the invention patent, the administration is going to check not only the formal requirements, which means that your identity documents are going to be okay, that the application form was submitted correctly, but also they will check the substantial requirements. They're going to check if the novelty is there, if the non-obviousness is there, etc. In the case of utility models, there's only a formal examination of the requirements. There is no substantial examination. Only when your company will try to enforce the utility model, those requirements will be checked. But if they're not going to be checked during the registration, this means that the registration process or the registration time is much lower. And it's true. While an invention patent takes between 3 up to 6 years to be registered, utility models are registered in less than a year. But why would the company invest double money for 2 intellectual property rights that protect the same technology? Because invention patents do not grant any protection while they are being granted. This means that if your registration process takes 6 years, then your technology will be made public because the process will make it public, and it will be unprotected for 6 years, which it may be the case that the technology life is less than that period of time, so the protection is useless. What companies or some companies do is to start a parallel registration of invention patent and utility model. By the time the invention patent is published, the utility model is granted. They use utility model to enforce and protect the technology. And once the invention patent is granted, they just discard the utility model and keep using the patent. This way, they manage to obtain the full protection of the patent, having at the same time certain level of protection thanks to the utility model. But what are these requirements? What do we need to register either a patent or utility model or both? There are 3 main requirements. The first one is novelty, means that the technology should be new. It shouldn't be known by any other person in the world. This means that you cannot disclose the information, you cannot show it to the public, you cannot start selling your products if you didn't start the application for the patents. You shouldn't disclose this information with clients, with partners, because if they know about this technology, they can claim for the nullity of your patent. That's why, as I mentioned before, while the patent is not being registered or till it is registered, during all the research and development part, it should be kept as a trade secret. The second requirement is a non-obviousness, which means that an expert on the field should not see the existing technology and came up very simply with a new one, the one that is trying to be protected. If it is obvious for an expert, then it's not possible to be registered as a patent. An industrial application is very simple, that the product should be possible to be made by an industrial process, or that the process should be possible to be used at an industrial level. In China, we have a new patent law. It will come into effect the 1st of June. Still, it's not in effect. But there are some specific aspects that are can be very relevant for companies. The first one is a patent extension. There are 2 main ways of obtaining the patent extension. One of them we don't care about here because it's for the medical sector, in which a drug company who is trying to patent a medicine and also trying to obtain the authorization to sell it in the market, as long as this market access approval is happening, the patent can be extended for the same period of time. But it's not relevant for the laser industry. Which is relevant is that if the CNIPA has a delay in the patent registration, this means that it takes longer than what it should take, then the company may be able to request the extension of the patent. Still, this is not enforced, so there are no precedents. We don't know exactly how they are going to be requested, what documents they may require, because the implementing rules were not published. But according to the new patent law, if there is a the company have to, or can ask for this extension. If it is not asked, it's not going to be granted. Also, there is a new, or there's going to be a new system to commercialize technologies, which with the open license system. The open license systems, what actually will allow companies to present the technology, the registered patent to the CNIPA, to request that anyone can get a license without even having to negotiate it. It doesn't mean that it will be for free. The company can choose the fees and some specific conditions. And if any company that just says, yes, I accept all the terms and conditions and start paying the fees, will be able to receive a license and using the technology. This will grant the companies the chance to commercialize the technology for obtaining extra profit and to, in some way, publish the technology, because since it's going to be available from the NFPA, it's going to be more or easier to be found by non-competitors. Of course, those technologies that are very relevant and the competitor may take advantage of that, and we want to, or we prefer that no one else is using it, this method of commercialization is useless. But it could be the case that your company has a technology that can be of use for other industrial sectors, and as long or as the more clients you have, the better. Then this system may be perfect, because you will be avoiding having to negotiate with every single client. You just set the rules, they're made public, and then they can just simply get a license, and you will have the CNIPA checking that they are paying the fees regularly. Also, another advantage is that those companies who include their technology in this system, there will be reductions or exceptions for the annual fees that they have to pay for the patents. Finally, the new law also brings some damages, or modifies the damages, including the statutory damages and including the punitive damages, making that an infringement of technology now is going to be more expensive to pay. The compensation is going to be higher. And as I mentioned, soon there's going to be new updates, because the implementing rules were not published yet. So most likely in the near future, we're going to have more news and to talk about. But as I mentioned before, that those technologies that are being in the process of develop, they are still not ready. They should kept as trade secrets and then register as invention patents. But it could be the case that the company may say, I just want to keep it as a trade secret. How should I decide when to protect it and when to keep it as a trade secret? There is a case that can be used to analyze the different factors. There was an Italian auto part company. They developed a new product that it was possible to release it in the market, and the other companies, the competitors, were unable to do reverse engineering and discover how the product was made. And they were wondering if it is better to register it or just keep it as a secret. And they analyzed these factors. First one, as I mentioned, reverse engineering. Since it was not possible to do reverse engineering, the product in the market was safe. No one was capable of learning the technology. They will also analyze the cost of registration, how much it was going to cost to register the patent, because for some companies, it's not affordable. Sadly, patents are expensive. The experts, the patent attorneys, they charge, yeah, very good. So for some companies, it's something just it's out of their budget, especially very small companies. But also you have the cost of enforcement. What happens if my product is copied massively here? Do I start a case against every single infringer? Yes, that would, sadly, that's the scenario. Can the company afford so many cases? We have to pay attorneys for every single case without knowing if you are going to win, and you are not going to receive any compensation till you win. So that may be a factor that takes you out of the market. So even if you have the patent, it's useless. And also another factor was checking the technology life cycle and how long it's going to take to obtain the protection. If by the time I have my utility model or my invention patent, the technology is already useless and has no commercial value, then it makes no sense to have the protection, because when I have it, I cannot make profit out of it. And in the meantime, it's going to be copied. So finally, this company took the decision to keep it as a trade secret because they were unable to pay, or if there is, or even if they were capable of paying the registration to enforce it, they didn't have enough resources. It was sort of protected because no one was able to copy, and they decided to keep it as a trade secret. Design patents. As I mentioned, design patents, what they protect is the aesthetic aspect of a product, how it looks, how it is presented. It's as simple as that. Even the registration process is quite straightforward, and it shouldn't last longer than a year. Basically, what you have to present is a picture or a draw about how the final product looks like, with the description of what it is, what it's useful for, and what are the main characteristics. Of course, there is also an application form with identity information, etc. What is important is that with the new patent law, there is a change with the partial or overall aspect. Till the moment, it was not possible to register partial designs. Only overall designs were protected, and this means that you have to protect how the entire product looks like. And if you have a graphic user interface, then the graphic user interface should be registered in combination with the final product. For example, I have the GUI for a phone, but if someone is using it for a tablet or a computer, it would be unprotected, except if I do the registration for those devices as well. With the new patent law, partial designs will be possible, and only part of products, also part of products will be capable of being protected. And this includes graphic user interface, because you can just simply protect in a screen, and that would be useful for any device. Regarding how to start the registration, well, in this case, even though we're talking about patents, we don't have PCT. PCT only works for invention patents. There is an international agreement called the Hague Agreement, but China is not part of it. So our only option is going to the CNIPA and start the registration with them. As I mentioned before, again, the same rule. If your company is based in China, you can apply by yourself with your own company. And if you are not based in China, you will need the assistance of a patent or design patent attorney. Copyrights. In the case of copyrights, as I mentioned, it's the main way of protecting software. And here we have to do or make a clarification regarding how to protect it, if it is necessary or not to do the registration. Technically speaking, because China is part of the Berne Convention of Copyright, the protection of copyright is automatic. This means that no registration is needed. As long as you finish your product, when you finish the final version, it should be protected immediately. But you have to prove later that you were the author of that product of that final software, and you have to prove that you made it in a very specific date. So even though the registration is not obligatory, it is highly advisable to do it, because we give you will allow you to prove that you were the one that made it, and that you made it in a very specific date. So any other copy that is made or trying to be registered in the future is going to be a copy. You can prove it very easily. And also here in China, the enforcement, or when you try to enforce intellectual property rights, if you have a certificate, it's going to be much easier. It's going to solve you a lot of difficulties regarding to prove. Copyright certificates are an excellent evidence. Again, what can I register? As I mentioned, you can protect software, you can protect databases, but also take into consideration that you can register manuals, you can register photos, pictures, draw, anything that you use to describe your product. If you're going to a trade fair, you can have your advertise protected by copyright. Why is this useful? Because if you're offering your products online and you are being copied, and you are being copied till the level that the person who's copying you is also using your own pictures, your own manuals, your own description of your product, then you may be able to take down this online website, this e-commerce link with a copyright infringement, even though you are not solving the final case, because you are not stopping them to producing the technology, which you can do. But at least you will be taking them out of the market or making their life more difficult. And this is particularly important due to a very unique jurisdiction. There is the jurisdictions of courts that are called internet courts, which are quite new. They only have a few years in China. They have the main characteristic that the entire litigation happens online, and they allow you to do the hearing of the case and to present digital evidence and finish the case in less than a month. On average, every single case is solved within 27 days. The problem is that their jurisdiction is quite limited. It only works for certain specific cases. Copyright infringement, the ownership of copyright is one of them, but for example, not for patents. So taking into consideration that also that if you go to a regular court, it could take years to obtain a solution, then the internet courts are the perfect alternative for taking down a link, not because my technology has been infringed, which may be the case again, but because someone is infringing my copyright. So you just take down the link, solve the problem in the short period of time, and then you keep working on the infringement of your technology and being properly compensated. So this is the usefulness of the copyright protection and the internet courts. Also, because it's thanks to the Supreme Court of China that allows the internet courts to accept digital evidence, you can obtain digital evidence with the usage of blockchain. So everything happening online is going to be quite simple to keep it as an evidence. Yeah, as I mentioned, because the procedure is so fast, that it shouldn't be an issue to obtain a resolution from the judge. And then we have trademarks. Trademarks, as I mentioned, it's any sign that allows your company to be distinguished from your competitors, your company and your products. You should register as soon as possible. Remember the first to file system. It is possible to take down a bad faith registration of a trademark because the trademark law established in the Article 44 that is possible. However, in practice, it's very difficult, It requires a lot of evidence, and it's going to be slow. It could take many years till you finally get back your trademark. So it's better if you are going to launch a new product, or if you are going to come to China, to do the registration in advance. How can I register? Again, we have the option of going with the CNIPA. In this case, it will be the trademark office, and start the registration by ourselves. Again, the same rule applies. If you're based in China, you can do it by yourself. If you are not based in China, you will need, in this case, a trademark attorney. But trademarks also have an international agreement, which is the Madrid Protocol or the Madrid System. This international agreement allows companies to start the registration in your own country, with your own office, using your own trademark attorney, or by yourself, and expand it to third jurisdiction, mainland China included. Here, be careful. It only includes mainland China, not Hong Kong, no Macau, no Taiwan. Hong Kong will be included in the Madrid system, but it's not part of the international agreement yet. So what you do with Madrid system will only affect mainland China. Also, there is another aspect to take into consideration. Trademarks, they're classified in 45 classes. Each one of them describes certain products or services. So if I want my trademark registered for a specific product, then I have to select that the proper specific class. China and the EU share the same classification. They use the NIST classification, and there is no problem with this. But China goes a step further and includes a subclasses classification. This means that each class has its own subclasses with a list of products or services. Because these subclassifications do not exist in the EU or in any other jurisdiction, when you apply with the Madrid system, you cannot choose which one are the subclasses you are interested in. This classification of subclassification will be done by the CNIPA when they receive the international application. It may be the case, because it happened, that this subclassification is done in a wrong way. That not all the products that the company is interested in are going to be protected, or that they directly, the ones that are selected, the company has absolutely no interest at all. So if you are applying with the Madrid system, please be careful that you will have to check which subclasses are going to be assigned. And if these are not the proper ones, then you will have an additional registration with the CNIPA to include all these products, to obtain a trademark for all these products. Finally, there is an important aspect of trademarks for China to be taken into consideration. That is the trademark translation. It is common for companies to translate their name or the product name into Chinese characters. They do it because many consumers are unable to read our alphabets the same way Western citizens most likely won't be able to read Chinese characters. So what they do is a phonetical or a conceptual translation. Phonetical means that they just replicate how the trademark is pronounced using Chinese characters. Conceptual is in the case that the trademark has a meaning, they just use the same concept using Chinese characters. The point or the important aspect to take into consideration, especially if what we use is a phonetical translation, is that we will choose characters to replicate sounds, but actually each single character has a deeper meaning. And we don't want characters with bad connotations in our trademark. From the marketing point of view, this is not desirable. So be careful when you do the translation, and do it with an expert. Now that we know what intellectual property rights are, how to register them, and what do they protect, let's discuss how to transfer technology, or what we should be careful when we are transferring technology. we can transfer technology, or we're transferring technology every time that, or almost every time, because we are transferring, when we are transferring knowledge, even know-how, we are actually transferring a potential patent. We're transferring a trade secret. But specifically, we're transferring when we provide the license, when we change ownership, or even when we offer a service. What law should I take, or should I check, should I take into consideration? The first one is the foreign investment law that will allow, or that regulates the investment that foreign companies can do in China and cannot do. These are very connected with other regulations, such as the regulation on the administration of the import and export technology, the catalog for prohibited and restricted technologies for import and export, and the negative list for foreign investments. In all these legal documents, we will see that certain technologies are restricted and some are prohibited for foreign companies. What's the difference of this? Well, we may face a circumstance in which we cannot import a technology to China, or even worse, that we develop a technology that we want to use it abroad, I mean outside China, and we cannot export it out of China. Or we would be in the situation that we invested and developed with a Chinese partner in the technology, we finish it, and then we discover that the company, foreign companies cannot own the technology, and it will remain in power of the Chinese counterpart. So we have to distinguish three types of technology. The freely importable or exportable means that there is no restriction at all, no problem. The restricted ones, which means that your company will have to request authorization to export it, import it, or own it. And the prohibited ones, that it doesn't matter if you ask for permission, it will not be granted, you will not be able to own that technology. So every time that you're starting a technology transfer, that you are going to invest in research and development, that you are providing a license, for example, be careful that your company keeps or can keep the ownership of the technology, that you are not infringing any law, that you are following all the necessary steps, because if you need to ask for permission, the permission should be requested first by the Chinese party, and it should be approved by the government, and then you can proceed with the contract. If you don't follow all the steps, you won't be able to enforce the contract, and which is important at the end of the day, if you're providing a license, you won't be able to obtain the royalties from them. So please be careful. Every time you are going to do a technology transfer and provide a license, be sure that your legal team consult ideally a Chinese expert, or at least consult these documents, and you know it's sure, or you know that you're following all the steps. But when we are sharing without the step of providing a license, we should take care of confidentiality. Why? Because I mentioned before, because of the trade secrets. We need to protect them with, I'm pretty sure you heard about it, the NDAs, or non-disclosure agreements, that basically states that all the information that is shared in a meeting cannot be disclosed to third parties, and if so, that the compensation should be paid. But here in China, it's better to go one step further with the NNN agreements, which is non-disclosure, no circumvention, and no use. The restrictions that your company impose to the Chinese party are gonna go further. Not only they won't be able to disclose, they won't be able to use the technology in their benefit, they won't be able to overcome the protection by, for example, protecting additional and complementary technologies. The important aspect, or what we have to take into consideration about NNNs, also NDAs, is that they should be enforceable. We should be able to enforce them with Chinese courts. So it is very advisable to have it in Chinese language, even if it can be that there is an English copy or any other language copy, but also please have a Chinese copy, because it's going to be way easier and you will be avoiding huge problems, because the Chinese court will request for a translation, and both parties will present different translations or discussions on who is right is going to happen. And this can be avoided by having a Chinese language contract signed. Also, it's very difficult because we sometimes receive requests of sending a sample of an NNN or an NDA. They have to be made tailor-made by an expert, because there are so many aspects to take into consideration that is almost impossible that the sample will be enforced here in China. But also, let's talk about licenses. What is a license? A license basically allows the usage of a technology by a third party. Remember the territoriality principle. We can only license technology in China if we have the technology registered in China. It has to be protected in China. Can we provide the license of an European technology or EU patent in China? Technically speaking, if they keep paying you, you will do it. But if the company wants the technology, because it's not protected, at the end of the day, it's going to be available. So maybe what they are doing is obtaining the know-how, then stop paying, and when they already know how to, or they already perfection how to do the technology, or how to do the product, how to do the process, they will just do it by themselves, because at the end of the day, you cannot enforce, you don't have the protection. So remember, protect and license, license everything that is already protected, and it's protected here in China or in the territory of your interest. In your license, you can include certain specific clauses. You can limitate what your counterparty can do. You can say that you are able to produce and to sell for a certain territory, that you will be able to take advantage of the technology for a short period of time, short or long, like a certain specific period of time. The license should be clear regarding the content. You should identify very well which technology you are licensing, or what trademark you're licensing. Everything should be very clear and specify. It could be several annexes, but please be very clear. Of course, you should include a clause for royalties. You should include a clause about control. That is critical, especially when we are talking about manufacture, that your company can do certain acts, like, for example, visiting the factory of the Chinese party, that you can check, that you can see the final products, that there is something wrong, that you have a voice, and that you can keep track, especially if they're limiting the amount of products they can produce, how many products they're producing, the amount or the quantity of the production. It is advisable also to include resolution methods and to establish what are the damages in case of an infringement. And also, especially if you are entering into a research and development agreement, but it could be the case that with the license it happens as well. You have to include clauses about what is going to happen if a new technology is going to be developed. What if they came up with an idea? Who is going to be the owner? Who is going to do the registration? Who is going to enforce it? How is it going to be protected? All these important aspects, it's advisable that you decide them in advance, especially, as I mentioned, in a research and development agreement. Include the ownership clauses, establish protocols So your employees or the people affected will have to notify that there is a potential new technology and include clauses on protocols about how to protect a new technology. If that the communication should be encrypted, for example, that all the employees or everyone who has access to technology will need to sign an NDA, or even that if there is, for example, a prototype, that the prototype has to be kept confidential in a closed room with no access to strangers, etc. Be very clear, very specific. Use not only the contract, if you are based here in China, use your manual of employees to establish these protocols and these rules, because they can be critical and can be the difference between protecting or not protecting a technology. Regarding the due diligence, is how to study a potential partner, a potential client. First, be careful with the made-up names. Sometimes Chinese companies, they present themselves with a very Western name, so it's easier for Western people to remember them. But this is not the legal name. Please always ask for the legal name, which should include the name of the city, so you get an idea of where this company is based. Because with the legal name, you can go to the National Enterprise Credit Information Publicity System, which is a database. And here you can check exactly who are the legal representatives, what's the capital, what's the business type, the business scope, if they receive any sanction, who are the shareholders. And this way you will be able to detect red flags if there is something suspicious, if there is a problem, who you will be dealing with, who to claim, etc. This website is available, it's public. You only need, it's very similar to a Google search. It's the search bar, you put the name there, and all the information will be disclosed. There is in our website, there is a guide on how to do this search. So if you need it in any circumstance, you can just visit our website and check how to do it, because of course this website is in Chinese, so the translation is, you can find it in the guide. And regarding enforcement, how to react if we see that our products have been infringed. First is to look for a lawyer, a Chinese lawyer or based in China. Don't forget to collect evidence, because you will be only capable of winning if you have enough evidence to prove what you are trying to say. And then decide your jurisdictions. As potential jurisdiction, you will see the e-commerce platforms, if it's happening in e-commerce, regular commercial courts or civil courts, the people's courts. There are also IP courts in the main cities of China, which are specialized in intellectual property rights. In the case of complex cases, for example, that involve patents, it's very advisable to go with an IP course, because the lawyers and the judges are experts on IP. They really can deal with complex cases. And if you go to a regular court, you may face a scenario in which the judge is not understanding what's happening. And yeah, the outcome will be more difficult to predict. You have the internet courts for copyright ownership infringement, as I mentioned before in the presentation. And also, if there's an infringement, you can always go with the criminal courts and prosecute the infringer. But what should I analyze to choose the jurisdiction? You should analyze what you want to achieve first. If you want to be compensated, it's better to go with the court. If you only want to take down a link, you can, or it's an infringement that is happening in e-commerce, you can just go to the e-commerce platform system. It's going to be a notice and takedown system, and it's going to be enough. Also, how much money do I want to spend? Because, for example, internet courts, you only will be paying for a lawyer for a month, and then with the regular court or IP court, it could take several years. How many infringers do I have? How much do I know? How much evidence do I have? With all these factors, you will be able to decide which is your jurisdiction. For example, if I don't have much evidence, or my evidence is only digital, then the internet course is interesting. But if it's not digital, it's going to be complex. Then internet courses are not such a good idea because everything is going to happen super fast. You won't have the time to explain properly all the evidence. Then go to a hearing is better, and going to the IP court may be better. And also, it may happen that you are contacted by a law firm proactively, saying that there is an infringement, that they want to take the case. We've been reported this scenario. Normally, we don't advise to go with these law firms, especially if you're talking about trademarks, because they want to charge for the paperwork, but they are not really following the best interests of the client. So, if you really to go with a law firm, but it's not going to be problematic if you decide that. But always ask for a second opinion, and always try to go with your own and lawyer and the person you really trust. Some takeaway messages: register your IP in advance, protect your unregistered inventions with trade secrets, combine the different intellectual property rights to protect your business, always study your partners. They are, know where they are, check if there is any sanction, study the law and bureaucracy of your sector, and contact public institution if you don't understand the market, if you want assistance, if you want someone that helps you to deal with the complicated counterparty that know more of the local culture and may be able to give you an advice about how to solve a very specific scenario. Always contact public institutions, and you can always contact the China as we have a helpline that is free, fast, and confidential. We reply within 3 working days. You can find our email, and you can find us also in social media. And that's it from my side of the presentation. We can continue with the Q&A section.
Thank you, Matias, for a very interesting presentation. I believe this information is very valuable for companies. So we have some questions from the companies. So I will start from the first one. In case of IP registered in EU but not in China, is Chinese company can patent solution even the case it was published in EU or US earlier?
Let me see if I understand correctly. This Chinese company can patent solution even in the case it was published. They can copy. The thing is, it works like this. The patent is going to be registered in certain specific jurisdiction. Due to the principle of territoriality, the protection is going to exist within the territory of these countries. Any other country that was not included in the registration, the technology will be free to use. So any company will be able to produce, to export, to import, to sell the products, and there is no infringement because there is no protection. So, and because of the novelty requirement in the case of patents, because the registration of the patent will involve that the technology will be published, thus it's going to be made available. There's not going to be any longer novelty. There is a grace period of time. So if we start the registration in one jurisdiction, we can extend it to a third one for a period of a year. But be careful when you plan the registration of the patent, because you have to plan very well in advance in which countries are going to be relevant. And because, again, IP rights at the end of the day, it's a set of monopoly over certain acts. The key countries or the key territories to choose are the ones that are your main market, but also the countries in which you may use for manufacture or even transit of your products. So I hope I replied this question.
Thank you. The next question, does PST extension to China takes 6 years too?
Yes, the PCT has two different phases. The first one is the international phase, in which you start the application with your own patent office. Then it goes to Switzerland when there is a search of precedent, there is a report, and then it's sent to China. And in China, the process, let's say, starts the same way as you directly present it with the CNIPA. So it's not only it can take 6 years, also can take even longer because it's a PCT. Normally, it's longer PCT than if you go directly with the office. But these 6 years that I mentioned is what is happening today. Like today, the average is between 3 and 6 years. The Chinese administration said that they want to reduce this time into half. They are investing on doing this, but it's still a promise. We still don't have enough information to say, yes, it is already happening, they're already improving. Hopefully they will, they promise they will. We will see it in the next months.
Thank you. Next question. Do you have any examples of restricted technologies in China?
Yes, I don't know them by heart because it's a list. It's a long list of technologies that are available online. But most of the restrictions are linked to military technologies, or that they involve some national interest, or that they can affect people's life. They are very, very specific, and they are. I have to say that sometimes the description of the technology is quite vague in the sense of it's very broad, but at the same time, they are for very specific areas in the sense of they are mostly related with national interest, military aspects, etc.
Thank you. Next question. What would be a way to enforce software license infringement? For example, client hacks software licensing system, copies, and sells software without purchasing the license.
What to enforce software license infringement? Software license. So if there is a license, what you actually have is a breach of contract. So, because the license at the end of the day is a contract. So it's not a matter of IP in the sense of that is an infringement of ownership, or that they are producing something that they are not authorized. It's a matter of they produce more than what the contract says. They produce and they sell in the place that they shouldn't. So I would say that regular civil and commercial courts are the ones for that, because we are talking here of not so much IP issue, but a breach of contract. And always, please remember to first obtain evidence before taking any further action, because that is a critical aspect.
Thank you. Next question. I would like to ask, what is the best way to protect companies' intellectual property while hiring Chinese personnel in case they would leave a company with sensitive trade and technical information?
Yes, that is a huge issue, not only in China, but in general for those companies, how to protect the technology to be stolen because an employee leaves, especially these key employees. In some cases, what they do is to establish in the working contract a non-competition rule. Means that if the employee is trying to leave or he wants to leave the office, then he cannot go and work directly for a competitor, and that they cannot use and disclose any trade secret, otherwise they would have to compensate the company. Again, this type of contracts they have to be very well drafted, because you limited so much a person. There are some limits. this person has to be compensated. The period of time that he cannot work for your competitor cannot be lifelong. It should be limited in time. So it's better to get, for the key people at least, get the legal assistance of a national attorney and make a tailor-made contract for that person. So that would be the case with the non-competition clause.
Thank you. Next question. Is it possible to register small patent utility model through PCT if no examination is being done? How it protects?
It is possible to protect it with PCT. And the second part, if there is no, can you repeat please the second part of the question?
Yes. So first of all, is it possible to register? And
Yeah.
if no examination, yes, if no examination is being done, how it protects?
When you try to enforce it, the substantial examination will be done. When I try to, let's say I try to enforce my utility model, then the counterparty will reply saying, oh no, sorry, your utility model is null because there is no novelty. Then I have to prove that it's new. So even though it is fast, at the end of the day, we won't be 100% completely sure that is going to be enforceable and usage till we actually try to enforce it. However, it is also true that in practice, companies that go for an utility model, they also go for an invention patent, and they know that the technology is going to be patentable. They know that all these requirements are complied. So it's very uncommon the scenario in which a company realize when trying to enforce a utility model that one of the requirements was not complied with.
Yes. Next question. So it looks that it is to apply for utility model patent is obligatory if one needs protection till obtaining China patent.
Looks to apply, not obligatory because it's not mandatory, but it's a very advisable thing to do because the registration process is so long and the technology will be available, which is at the end of the day, it is very advisable. So I cannot say it's mandatory or obligatory because it's not that you need to obligatory start both registration in parallel, but I would say it's a smart thing to do. Yeah.
Thank you. Next question. We have companies in both European Union and mainland China. A company in China is wholly foreign-owned enterprise and owned by a company in EU. Considering trademark legal issues, is it easier and faster to win if trademark would be registered by EU company or wholly foreign-owned enterprise in China? Would it be the same advice for the other IP registration ownership?
Regarding that, I would say there is no difference. It's not easier or faster. It's only a matter of a requirement. If you are not based in China, you need to have an attorney. If you are based in China, you can do it by yourself. But this is only for the formal examination to prove what documents you will be requested to show when you are doing the registration. Then the registration process itself, and the sense of the checking of the requirements, etc., it's not going to be faster or different. And regarding to the moment of enforcement, it's not going to make a huge difference if you are like if you are the company from the EU or if you are a company in China. It's only a matter of what document you will have to show, but you're not going to receive more or less protection for that. No, I wouldn't say there is a significant difference, at least. Of course, it always happens that the companies that are already based in China, they have Chinese employees that they help with the language barrier. It's easier for them to, if there is any problematic, to deal and address the authorities faster. They are in the same time zone, etc., etc., etc. But these are non-legal aspects or non-legal benefits that being in China gives you, and not if you are not, if you are in the EU.
Thank you. I have some additional questions. Companies can think about more questions if they have. If a company plans to set up a joint research project with a Chinese partner, whereby both of them would create a new IP or improve existing IP, what should they pay attention to in terms of IP protection? How can they ensure that they own their core IP?
We practice in the channel with both IP. What we should pay attention to is to pay attention to the ownership rules. Because it's a new technology is going to come, you have to be sure that your company will own certain part of the technology at least. Also, you have to pay attention to all the measures you're going to take to protect this future technology, this up-to-come technology. Because again, think in the example of patents and the novelty requirement. If the technology is being disclosed and it's been accessible for competitors, no patent will be possible, no protection, and the technology is lost, or not lost, made public to everyone. So those are the main aspects to take into consideration.
Thank you. Another question. When looking for a potential partner, company needs to describe their laser system used for welding and brazing in great detail. How can they protect their trade secret in this case?
Well, in this case, it would be necessary to have an NDA, or even better, an NNN agreement, which has to be tailor-made and has to be very specific about what information is going to be disclosed, and has to contain a very well-drafted damage clause. So it has to be very obvious and very clear what are we giving to this company, which information are we giving to this company, what descriptions. It could be copies of the draw that we are giving, or a presentation. It could be even a record of the meeting. And it has to be very clear that if this information leaves the room, that company will be responsible, and that company will have to pay this amount of money, this damage that is going to be included in the agreement.
Thank you. And the last question from my side. Let's say my product does not meet the novelty requirements of invention patent. Would it make sense to still have utility model patent? Can it act as any deterrent against potential infringement, even if cannot enforce it?
Technically speaking, if you don't have the novelty, you won't be able to, or you shouldn't be able to have a utility model. So if you try to enforce it, you will fail. But because you're going to be granted with utility model, because novelty is not going to be checked, you will be able to have it, show it, and use it for example, starting a negotiation to threaten, I'm going to sue you with this utility model if you don't stop. If the other company knows your technology very well, most likely will know that this utility model is useless. But it could be in very specific cases that you are allowed to do this, to use this utility model as a way of threatening companies. I will say that that depends a lot on the product. If the product can be copied massively, so that means that can be even copied by people who may not be aware or know very well the market and what are the last news, what is really happening in this sector, then in this case it would make some sense. But if it's only a set of competitors, that they know each other very well, they know what the technology is very well, then you wouldn't be able to threaten them because they will know that this utility model is useless.
It is clear. So I see that we don't have any questions. My last call, would someone want to ask using this last opportunity? If not, with him directly and to discuss the questions you are worried about or interested to know. So I believe you can do that, and I encourage you to do that. And I will ask a question in Lithuanian now. It is only for us to know. Kolegos, ar jūs neprieštaraujate, kad šitas webinaras būtų pasidalintas viešai ir būtų patalpintas jų svetainėje? Jeigu prieštaraujate, jie to nedarys, jūsų vardai nėra minimi, matysis tik tai bendras vaizdas ir, žinoma, aš, kur klausinėjau ir kalbėjomės. Tai tiesiog norėčiau žinoti, jeigu yra kažkokių tai prieštaravimų, tai parašykite tiesiog dabar ir žinosime, kad turime paprašyti jų, kad jie nesidalintų šitą informaciją. Taip, tai kol kas matau, kad kaip ir prieštaravimų nėra. Tai šitas webinaras atsiras viešoje erdvėje, jų online puslapyje ir visada galėsite užeiti ir pasižiūrėti, atsišviežinti žinias būtent apie tai, kas buvo kalbėta šiandien. Okay, Matias, I just explained about this webinar possibility to went online. And there is, at the moment, I see that there is no objections. So no problem at all to publish it online.
All right.
So I believe,
as you explained, if any company after the webinar or during this week, so whenever you need assistance, wants to contact me, you can do it with the helpline. We can arrange a Zoom call or a video call so we can discuss your case in particular, and maybe you can ask all the questions that you want and that concerns to very specific case. So thank you very much for listening to me. Here you can scan our QR code if you already have WeChat. Thank you very much for the invitation and the opportunity.
Thank you, Matias, very much one more time for your presentation. I think it was very valuable, and I believe that companies will reach you already individually to clarify the questions they have. Thank you one more time. It was very important to know this information.
Thank you.
Have a nice day, and I also wish a nice day for Lithuanians. And bye-bye.
Bye-bye. Have a nice day.